Supreme Court stands in the breach, and John Roberts says no to the far right. The Chief Justice is behind a very important ruling that rejects an out there legal theory that could have let states count your votes, actually not count your votes at all, I should say. CNN's Joan Prescupik joins me at the table, and David Chalian is still with us. This just happened this morning, Joan. Explain, there's so many different fascinating nuances to this, but as you give your answer, I want to put up on the screen what the outcome was, 6-3.
Exactly right. First of all, this was a case that could have been moot. And John Roberts said when he announced it from the bench that there was a strong argument for mootness, and they decided they were still going to handle it. But he said, that part of my opinion doesn't lend itself to oral presentation. So I will skip it too, Dana. Because
let's get to what the it is.
Exactly.
Because I didn't
because
fully
they
explain
brushed
it.
away, lower court developments in North Carolina and decided to take on this very important question of whether state legislatures have complete and independent control over setting election rules, drawing redistricting maps without a check by their state Supreme Courts, looking to their state Supreme Court, state constitution protections. For example, for equality, and that was at issue here was an extreme partisan gerrymander in North Carolina that the state Supreme Court had rejected for equal protection voting rights reasons. And the Republican-dominated North Carolina legislature had come to the Supreme Court saying, you should rule that state legislatures are essentially insulated from this kind of check by state courts because of the Constitution's elections clause, which says that state legislatures are responsible for the time, manner, and place of elections. Chief Justice John Roberts, 6-3 vote. Once they got to the merits, I think this was understandable because North Carolina was pushing such a hard argument, said judicial review is such a part of our Constitution, our country, our Constitution for both state courts and federal court judges, and we are not going to eliminate it now.
So to boil it down, what they were listening to was an argument that the legislatures in all 50 states can take the votes and change them and overturn them, the vote that comes out of the state. And the fact that the court, they had the option to just reject it and not rule on it. The fact that they made the decision to rule on it and did so with the 6-3 majority meant that they wanted to, as we said, drive a stake through this idea.
Right. And also, I think with 2024 looming, they probably thought, do it now, because there were challenges coming down the road that were similar. Do it now, do it outside of a presidential election year, and get it done with. And it was very decisive.
Much better for democracy to not do that in the heat of the election or retroactively, but to do it ahead of time. This is good for democracy. I mean, this is good because of the 6-3 nature of the ruling as well, and that it is from different political corners that you see people coming together. But Dana, think about what you're saying. I mean, think about the argument that Donald Trump was having with Mike Pence when he was asking him to send it back to the states. Well, if this somehow ruled differently, and this theory that state legislatures had total autonomy over this, Mike Pence may have come to a different conclusion. And then these different slates of electors, not representative of how those states voted, may have been sent. It just unravels from there. This ruling now continues to keep some guardrails in place for the democracy that are incredibly, incredibly important.
In a 6-3 decision, justices rejected a case out of North Carolina that argued state courts have no oversight in reviewing election rules. Rules, we should note, that would be decided by potentially partisan state legislatures. The theory, you might recall, was bolstered by backers of the former president following the 2020 presidential election. CNN's Jessica Schneider was at the Supreme Court earlier today when this decision came down. Put this into context for us, Jessica. Why is this case so important?
Boris, this is really the Supreme Court working to put a preemptive stop to any potential election chaos as we head into the 2024 election cycle. So what this is saying is that state lawmakers of any party, they do not have the final say in determining what election rules, election laws, even voting maps will go into effect. They essentially do not have carte blanche to enact whatever rules they want. And state courts can step in to rule on whether those laws or rules are actually constitutional. Now, this is a much different outcome than what these conservative challengers had pushed for here. Conservatives, especially those backing Trump in the 2020 election, backing his efforts to overturn the 2020 election, they had pushed this theory known as the independent state legislature theory, saying that because the federal constitution says that legislatures are the ones who are in charge of the time, place, and manner of elections, that legislatures only should be able to prescribe what the rules are surrounding federal elections. But the Supreme Court today, in a 6-3 decision with Chief Justice John Roberts writing the opinion, saying no, that isn't the case, that state courts do have a role here. This is from the opinion that Roberts wrote. It says state courts retain the authority to apply state constitutional restraints when legislatures act under the power conferred upon them by the Elections Clause. And he did continue to explain how historically state courts, federal courts, they have routinely stepped in to maybe put constraints on a state legislature or even a federal legislature if they enact certain laws. As we see, that's the power of the courts to review these laws. This is a decision that no doubt has been celebrated by voting rights groups. We even saw the former president, Barack Obama, celebrating this decision from this court. Barack Obama wrote this. He said, "They rejected the fringe independent state legislature theory that threatened to upend our democracy and dismantle our system of checks and balances by giving state legislatures near total control of federal election laws. This ruling is a resounding rejection of the far-right theory that has been peddled by election deniers and extremists here." I will warn one thing. In this opinion, the Chief Justice, in writing it, did say that state courts don't have, quote, free reign, putting some information in there about maybe federal courts reviewing state court decisions. So while this does sort of put the kibosh on free reign for state legislatures, there could be some litigation in the future depending on how state courts step in when it comes to elections. So there will be further litigation, but at least for the 2024 election, things should be chaos-free, perhaps.
Some foreshadowing there from the Chief Justice. Really a complex legal case and not their final decisions. Some big ones coming up potentially over the next few days.
Exactly, by end of the week, likely.
We know you'll be back to discuss them. Jessica Schneider, thank you so much.